Warren can lead it off. She had the first dibs on bill introduction. Senator.
Well, thank you, Mr. Chair and committee. I'm Kelly Warren, honored to represent Senate District 11, and I do have a bill introduction for, a bill to request introduction of, and it is 25 RS 1057, modifying the Board of the Kansas Public Employees Retirement System investment standards of monies certified by the State Treasurer as equivalent to the aggregate net amount received for unclaimed property to authorize investment in certain foreign governments.
Okay, committee, any questions or objections to introduction to that bill? Seeing none. Oh, do you have a question, Senator Falscadeau?
Thank you, Mr. Chairman. Not a question, Senator Kelly. I just actually found $200 last night on the unclaimed property site. So I just want to share that, Mr. Chairman.
Great, and constituents are always happy when they discover there's unclaimed property that belongs to them. So it's a service that you should reach out to your senator or your representative. There might be some help there to find some unclaimed property that's yours. So
50 cents in his couch. Okay. Any other questions or objections? Seeing none, that bill is introduced.
Thank you, Mr. Chair.
Let's see. I think Senator Francisco is up next.
Thank you, Mr. Chair. I would like to ask for the introduction of 25 RS 1065. This is at the request of Senator Holscher. As committee bill, it would prohibit ICE raids in places of worship, schools, and hospitals.
Committee, any questions or objections to introduction of that bill? Seeing none, that's introduced. I think Senator Falscadeau had some and Senator Dietrich had some. So we'll go to Senator Falscadeau next.
Thank you, Mr. Chairman. My bill, the RS number is 0393, and it's a bill to kind of give a second look at young people who are incarcerated under the age of 14. Thank you.
Any questions or objections to the introduction of that bill? Seeing none, that is introduced. Senator Dietrich.
Thank you, Mr. Chair. This probably belongs in local government, but they weren't meeting today. So this is an act concerning, it's an RS number 0262, and it's just relating to real property, covenants, conditions, and restrictions.
Okay. Committee, any questions or objections to introduction of that bill? Seeing none, that is introduced. Any other bill introductions? I've got a couple here. I've got one from about E-Verify. It's 25 RS 0889. Committee, any questions or introductions? Questions or objections to the introduction of that bill? Seeing none, that's introduced. Next has to do with, it's 25 RS 0869, and that has to do with campaign contribution limits. Any questions or objections to introduction of that bill? Senator Falscadeau.
Thank you, Mr. Chairman. So limits to how much we can
take in, yes, exactly. We think that some of the limits are outdated and not necessarily, particularly for some county elections, they should be increased. So that's what that bill's about. Any other questions? Seeing none, that bill's introduced. And then finally, 25 RS 0279, which has to do with public benefits for illegal aliens or illegal immigrants. Any questions or objections to the introduction of that bill? Seeing none, that is introduced. Any other bill introductions? Seeing none, I think we're done with that. Since we're reaching the deadline for our non-exempt committees, the bills are flooding fast and furious. Okay, we have a hearing this morning on Senate Concurrent Resolution 1604, which is making application to the United States Congress for an Article 5 convention and to propose amendments to the limits of the federal government. And I'll have Jason give us a bill brief on SCR 1604.
Thank you, Mr. Chairman, members of the committee. Senate Concurrent Resolution 1604 is a reintroduction of a resolution from a couple years ago. It would have the legislature make application to the United States Congress to call a convention of the states for the purpose of proposing amendments to the United States Constitution. And the purpose of those amendments would be to impose limits on the federal government. Article 5 of the U.S. Constitution grants Congress directly the authority to propose amendments to the U.S. Constitution, and alternatively directs Congress to call a convention of the states upon application by 2/3 of the states, or 34 states, who apply for such convention. And then at such convention, if any amendments are adopted by that convention and proposed, then those must be ratified by 3/4 of the states, or 38 states, to become effective. The purposes listed in the concurrent resolution really start down on lines 32 on page 1 and go over to page 2, looking at imposing fiscal restraints on the federal government, limits to the power and jurisdiction of the government, and term limits for members of both the U.S. House of Representatives and the United States Senate. And so this would be effective upon adoption under current state constitutional provisions. It requires a 2/3 majority in both chambers in order to be adopted and become effective. With that, Mr. Chairman, I'd be happy to stand for any questions.
Thank you, Jason. Committee, any questions? Senator Gossage.
I just want to clarify, Jason. So does this resolution stand as the state of Kansas application as one of the states?
It would, for the purposes specified in the resolution.
Okay. Thank you. Thank you, Mr. Chair.
Committee, any other questions? Seeing none, thank you, Jason. We appreciate it. Committee, we have verbal and opponent testimony on this, and given the time limits, I think we're going to do 15-minute blocks and then have stand for questions at the end of each of those blocks for our proponents and opponents. So up first, we have David Schneider for the Convention of States. And David, welcome to Federal and State Affairs. And the 15 minutes begins now.
Thank you, Mr. Chairman, members of the committee. SCR 1604 is the exact same legislation, essentially, that I've been in support of and bringing to the legislature for the last 12 years. This is the reason I first came to Topeka, as to take on this initiative several years ago. So I'm here to answer any questions that you might have regarding this particular piece of legislation and maybe the history here in the legislature on this particular piece of legislation. But I'm going to sit down and let some of the other folks that are proponents take the bulk of the time. Thanks.
Thank you, David. Up next, we have Ben Terrell. Ben? Sorry about that. I didn't have my mic on. Ben Terrell.
That's quite all right. Chairman Thompson and members of the committee, I am the legislative liaison, the volunteer, I want to make that clear, legislative liaison for Convention of States here in Kansas. I have been in this role since late 2018, and I represent the thousands of Kansans who have signed our petition and dozens of active volunteers like myself across the state. When I signed the Convention of States petition 9 years ago this month, there were 6,500 petitioners across the state. Today, I looked just last night, there are over 47,600 petitioners across the state. So my point is, we are a large and growing grassroots organization. Thank you for hearing testimony on our resolution today. We asked you to hear it because all of us have come to the distressing conclusion that finding the best candidates and electing them to office in Washington no longer secures our rights in the Constitution from the federal government itself. We find that the government in Washington has, in fact, become an enemy to our liberty. I'm just speaking plainly. And that the vested interests there will not relinquish their control. We ask you to help us restore Lincoln's vision of government of the people, by the people, and for the people to our country. How can you help us do that? The framers provided a way for any power of the federal government that were out of order to be corrected. Checks and balances, right? The way provided to the people to restore constitutional order when the federal government is out of order is through you, the state legislatures. In Article 5 of the Constitution, you are authorized to initiate amendments, as Jason read to you earlier, without waiting for or groveling before Congress when 2/3 of the states, 34, pass resolutions on the same subjects and then meet to deliberate and draft amendment proposals. I'm sure you recall that any amendment proposals for the Constitution, however initiated, must be ratified by 3/4 of the states, which is 38. Jason also reiterated that. You have always known you were in charge of the ratifying process, but it has generally been forgotten that you have an equal right with Congress when it comes to initiating amendments. It may help you to know that the Kansas legislature is no stranger to this process, having passed 8 resolutions for amendment conventions between 1907 and 1978. 2 of those resolutions are still outstanding. One from 1951 for to place limits on federal taxing authority, and one from 1978 for a balanced budget amendment. Our proposal has been brought to this committee 3 times beginning in 2018, and it has passed favorably out of committee on each occasion. Each of these resolutions were heard on the Senate floor. In 2018 and again in 2023, the resolution lost on, coincidentally, similar votes of 22 for and 16 against, since the Kansas Constitution requires an affirmative vote of 27 members. In 2021, the resolution was referred back to committee on a vote of 19 to 21. So finally, we are here asking you again to use your authority to oblige the federal government to control itself. Take action so that Kansas can join the 19 other states that have passed similar resolutions, and so bring us closer to the 34 needed to call a convention to propose amendments and restore our constitutional order. Thank you.
Thank you, Ben. We have next Michael Ferris on WebEx, and he is LLM for the, for the Convention of States. Mr. Ferris, are you there?
Yes, Mr. Chairman, I'm here.
Okay, we can hear you. Go right ahead, Michael.
Okay, Mr. Chairman, thank you so much for the chance to be here. I was there with you in person last year, and it's an honor to be before you today. I am the co-founder of the Convention of States Project and constitutional lawyer. I've argued in many courts, including the Supreme Court of the United States. I represented the state legislators from Washington State on an Article 5 matter relative to the ERA many, many decades ago now, and that case ended up in the Supreme Court of the United States. So I'm one of the few lawyers that actually litigated in the Article 5 area. The reason the founders gave us this form of the provision was a last-minute addition initiated by George Mason. He stood up at the Constitutional Convention in Philadelphia in 1787 and said, someday the federal government's going to abuse its power. When that day comes, if you only give Congress the authority to propose amendments, they'll never propose an amendment limiting their own power. And since the founders were absolutely committed to the idea that no one should have unchecked power, this provision was put into the Constitution without debate, without dissent. Everyone saw the absolute sense of what George Mason was saying, and they immediately adopted a provision in the current form of Article 5. There have been 450 applications for a convention of the states in the history of our country, but we've never reached the 2/3 majority on a particular topic. This resolution that's in front of you that I helped to draft, the operative language, I basically was the original draftsman of it, has been adopted in 19 states, and the language is verbatim in those states. So there's no question about the agreement of the states to join together. And we're making progress getting toward 34 on these particular topics. This convention would be a one-way ratchet. It does not allow for the increase of federal power. It only allows for the decrease of federal power. In term limits on federal officials, fiscal restraints on federal officials in the federal government, and to limit the size and the power and jurisdiction of the federal government. Some of the abuses that we hear about in the last several days of spending $53 million for this and $150 million for that are coming to light now that Elon Musk and others have gotten access to some of this data, are staggering as to what's going on. But while these things can be fixed immediately, our resolution provides a structural limitations. So not only do we fix them this time, is that it can never occur again. And that's what we're trying to do, is to be able to make sure that the federal government puts the genie back in the bottle. The concern that's typically raised by people in states like Kansas is that there's a possibility, is claimed, that the convention will run away and will not be limited to the power. There are numerous reasons that that's not true, but I'll focus on the primary reason. The primary reason is that the Supreme Court of the United States and other federal courts have made it clear through the ERA litigation that you can't change the rules in the middle of the stream in the constitutional process. The ERA was given 7 years for ratification. There have been 2 separate efforts to change the rules for that. And every court that has looked at that question says, no, you cannot change the rules in the middle of the stream. We've had 450 applications for a convention. We've never had an agreement because the topic is an absolute prerequisite. 2/3 of the states have to agree on the topics before you can have a convention. If 34 states call for a convention for the 3 topics listed in our resolution, that's it. You can't go on and discuss other topics. So things that would implicate the Bill of Rights, they're not topical. You cannot bring those up. And so just for an example, anything that's not listed, you cannot bring up lawfully. And there's binding court precedent that says that the rules can't be changed in the middle of the stream. Now, beyond that, even if that fails somehow, and I don't see how it possibly could fail, but even if it could fail somehow, still 38 states have to ratify. As difficult as it's been over the last 11 or 12 years to get 34 states to call for a convention of the states are very careful about this. The chances of us seeing something crazy come out of a convention and then get ratified by 38 states is just political fiction. People see bills introduced in legislatures all the time that they don't take seriously because there's not votes for such a proposition. There's not votes for the idea of some of the horror stories and the fear-mongering that goes on here. It simply could not happen. And we allow the federal government to accumulate $36 trillion and counting in debt because the states have not been courageous enough to stop them from doing this. We need 34 states with the courage to stop this abuse of power, and we urge Kansas to become the 20th state in that process. Thank you.
Thank you, Mr. Ferris. We have one other WebEx proponent, Michael Fame. Michael, are you on WebEx with us? Michael? A different Michael, not Michael Ferris. I am not hearing him. We don't have him, Messiah. Okay. I think Michael said he would allow just his testimony to be written. Committee, we have, including Michael Fame's written testimony, 7 other proponents who provided written testimony on SCR 1604. So we've gone 11 minutes and 49 seconds. And so, committee, I'm going to open it up for questions for any of the proponents of the bill. Senator Gossage.
Thank you. Ben or anybody else who would like to come up, please, to answer the question. You're right. The Michael that was talking about, the fear mongering. We've all heard that as legislators, particularly because there's like Okay, well, what amendment, they're wanting to add an amendment to the Constitution. What amendment would there be to add? Is there something in mind as to what the amendment would look like?
We, Convention of States, trust the state legislatures, to work out the exact wording of those amendment proposals. But our topics are, as Mr. Ferris indicated, and as the language itself indicates, are limited to three things. Fiscal restraints on the federal government. So that could be a balanced budget amendment. It could be like three amendment proposals. One could say Congress can no longer cannot spend, authorize spending beyond 3% of GDP in any given year unless a national emergency has been declared. It could be a combination of those types of things. Next issue is term limits on federal officials, is the way our language is. So that doesn't have to be just Congress. It could also apply to the bureaucracy. There could be language to the effect of no one shall hold federal employment in Washington for longer than 20 years or 25 years, those types of things. And the last one is limit the scope and jurisdiction of the federal government. And what we're getting at there is the Supreme Court decisions that were handed down in the 1930s, the late 30s, that redefined the Commerce Clause. And you may remember the Constitution limited Congress to regulating interstate commerce. We all kind of have an idea what that is. Selling Kleenex that's made in Texas here in Kansas. But what the court decided in the late 30s was that whether it was interstate commerce or just in the state, it could be controlled by Congress. And so today, they control what kind of light bulbs. It's now illegal to manufacture, distribute, or sell or buy an incandescent light bulb anywhere in the United States, and you'll be fined and can be imprisoned for that. And nobody voted for that.
Thank you very much, Ben. And Mr. Chair, I would just add, we've all seen the overreach of the federal government. And honestly, it usually comes with funding.
Yes.
Well, if you don't want the funding, then we won't do this. But, if you want the funding, and that's been an issue for a long time. Thank you, Mr. Chair.
Thank you, Senator. Senator Clifford.
Thanks, Mr. Chair. I'm not sure if Ben wants to address this or maybe Mr. Ferris with his credentials, but I understand there was a court case involving the Kansas threshold to get this moved. I'd like to hear the status of that.
I think Mr. Ferris would probably be the best one to answer that one. Michael?
Yes, I'm lead counsel in that litigation. It's pending before the federal court in Kansas right now. There are multiple decisions of the Supreme Court of the United States that say that state constitutions cannot be used to control the process of amending the Constitution of the United States. Those cases usually involved people wanting to say that the power of referendum or a ballot initiative should be applicable to this. But there have been a variety of contexts. And there are a number of cases that have held that states cannot impose additional requirements through the state constitution on the process of amending the federal constitution. So we're waiting for a ruling. The briefs are all submitted. The judge may or may not schedule oral argument. But by way of background, your prior attorney general issued a ruling that the Kansas Constitution was in violation of the United States Constitution. There were some caveats to that about legislative rules, but on the constitutional level, the prior Kansas Constitution agreed with what I just told you about the correct state of the law vis-a-vis comparing the U.S. Constitution to the Kansas Constitution.
And in fact, I think they called it precatory in that opinion from A.G. Schmidt, that the Kansas Constitution was precatory, meaning it was just a suggestion. But it's how we operate. Did you have a follow-up, Senator?
Thank you, Mr. Chairman. That's the answer I wanted. Thank you.
Yeah. Any other questions? Senator Fasquedo.
Thank you, Mr. Chairman. I think my question would be for the first gentleman, David. So, previous testimony said that it's 34 states are needed. Could you clarify, did you say you already have 20 states or 32 states? And then, Mr. Chairman, David, if in fact Kansas passed this, what would be the process or the duty from Congress to implement? Thank you.
Mr. Chairman and members of the committee, yes, the process is spelled out in Article 5. Specifically, 34 states must make application. That means pass this very piece of the legislation before they're added to the list of states. There are other calls, as Mr. Terrell had testified towards, that Kansas is already a part of. Those efforts stand at different numbers. I can't speak to those particular efforts and how many states they have. But one would argue that the balanced budget amendment process, they're going through that process as Kansas has signed on to, is somewhere in that neighborhood that you mentioned of 30, 31, 32. I'm not 100% sure where they stand on that effort. This effort has 19 states currently. We're looking to become state number 20. And I'm sorry, I don't remember Congress's role in this process. According to the U.S. Constitution, as soon as the prerequisite number of 34 states have applied, Congress shall call a convention of states.
Committee, other questions? I do have one for Mr. Ferris, and that it kind of is a follow-up on that Article 5 on details of how the convention would operate, how delegates would be selected. I think, is it not the individual states that would determine how they select and send their delegates? If you could weigh in on that. We can't hear you. I think, is he muted?
Okay, how about now?
There we go. We're
Can
good.
you hear me?
Yes.
All right. In historical documents, for example, in the very first Article 5 application made by the state of Virginia in 1788, it refers to the term convention as states. And that's a term of art, meaning that the states meet as states, and it's one state, one vote. In all meetings of the states, Kansas is a member of about 40 interstate compacts. Every interstate compact in the history of the country that I'm aware of, and I've looked at hundreds, it's always the equality of the states. And so what we know is it's equality of the states is an absolute prerequisite. We also know from the experience of 1787 that the convention delegates are controlled by their states. When there were questions about their authority at the convention in 1787, the protocol used was to look to the instructions delivered by that particular state's delegates. For example, New York's delegates were not allowed to vote unless all three members were present. So about July of the convention, two of the delegates from New York got mad at what was going on, left. Alexander Hamilton stayed. He was able to debate, but the convention never let him vote again because to do so would have violated the instruction from the state of New York. So the states name their delegates, the states give their delegates instructions, and many states are passing laws parallel to this application, giving the details of how they will select their delegates. But the short answer is this body, the House and the Senate together, would name your delegates. And if you send 3, if you send 5, if you send 7, that's kind of up to you. I mean, you can send whatever your number you want, but you want an odd number that's not too big and not too small. But they would vote as a block. Whatever had the majority vote of the delegates would cast Kansas's vote, just like it was done in 1787. And just one final thing, if anyone argues that the 1787 convention was a runaway, they are defaming the Constitution of the United States. That's not what happened. I wrote an article in the Harvard Journal of Law and Public Policy. It's the Conservative Law Review at Harvard Law School. And you can get it on the internet for free. Just my last name, Farris, F-A-R-R-I-S, and the phrase, defying conventional wisdom. And you can read that it's just not true. The states called the convention. The delegates were told to render the federal constitution adequate for the exigencies of the Union. And the idea that is a runaway is actually defamatory against the legitimacy of the Constitution of the United States. And I think we all should try to uphold the legitimacy of the Constitution. Thank you.
Thank you, Mr. Ferris. Any other questions? Seeing none, that's it for our proponent's testimony. Well, I think we probably better move on. We'll just let him know Michael Fame is on, but I think we'll move on and put his testimony in written testimony only. So sorry about that, Michael. So we'll move on now to opponent testimony. Up first in a 15-minute block, once again, is Daniel Chase. And Daniel uses little as much as the 15 minutes you want. And we'll start now.
Thank you, Chairman Thomas and members of the committee. I would like to remind every one of you, this right here is the Kansas Constitution. Every one of you swore an oath to uphold this Constitution, and you said so help you God in that oath. Now, people can say that the federal government's out of control, which is absolutely true. But is the solution really to go and ask the federal government for permission to violate your own oath? Every one of you. It is shameful as a Kansan to have people that are turning around and asking the federal government for permission to violate their oath to the Kansas, to us, under God. They made an oath to the Constitution. There is a 2/3 supermajority requirement in that Constitution. What they're doing is they're trying to rein in the federal government by asking the federal government to overturn our state constitution. And the problem is that the federal constitution is not enforced. By and large, much of it goes unenforced, and nobody, pushes back much on it. Truly, not in the ways they should be. If our representatives can actually make a lawsuit in a federal court, that's a bad actor. They are turning against their oath. And so if a representative isn't bound by his oath, then what will a delegate be bound by? When you look at the first convention, they were all called under the Articles of Confederation, every delegate. Every state sent their delegates under the Articles of Confederation to amend. What happened was they wrote an entirely new constitution. Madison himself in Federalist Number 40 says that the delegates stepped outside the tenor of their commission. These are historical facts that I've pointed to before in previous testimonies. I don't know if it was in this committee or not. I've submitted in a few different places. But at the end of the day, if our own representatives are trying to violate their oath that they took, how can this committee promise that delegates will be held to a higher standard than our own representatives? That's really all I have to say.
Okay, thank you, Daniel. Next, we have via WebEx, John Axtell, Kansas Campaign for Liberty. Oh, John's here. Okay, there he is. Okay. Never mind on the WebEx.
I'm doing fine. I was a little under the weather on Friday, so arranged for that possibility. Thank you.
Very good.
Yep. Honorable Chair and committee members, I am John Axtell, and I'm the volunteer coordinator from Wichita for Kansas Campaign for Liberty. And I, Honorable Chair and committee members, I do oppose SCR 1604 for several reasons. But most important is the fact that nothing about the convention can be constrained. And a recent lawsuit, as has been mentioned, offers clear evidence that this fact is true. Now, this lawsuit has been filed by 2 Kansas legislators asking federal court for permission to allow the Kansas legislature to essentially ignore the Kansas Constitution when applying for a constitutional convention under Article 5. Now, the lawsuit proves what we have been saying for years. This process of applying for and holding a convention under Article 5, quote, cannot be constrained by the people of Kansas. Those are not my words. Those are the words from the letter from the Attorney General, 2019-10, mentioned previously. And that letter did, in a sense, argue for this lawsuit. Now, notice that I'm referring to documents to which you can access, okay? Notice that when I refer to a decision or a letter, I'm giving you the precise way to access that data. Please notice that, in contrast to some previous testimony. Now, the words are, again, from the words of the Dyer versus Blair case, the words of the AG letter are pertaining to the 1975 Dyer versus Blair case, which is the legal basis for this lawsuit. Now, the 1975 Dyer versus Blair case, that is another case that you can access on your own. And if you need, I can send you a copy of that. So I'm not throwing around this Supreme Court decision or that Supreme Court decision without telling you precisely where those decisions are from, right? That's the way I work. So the words of the Dyer case are very important, and they said that the legislature, when participating in a federal process, is free to, quote, accept or to reject, end quote, the supermajority requirement in the state constitution. So the legislature may reject the supermajority requirement, so the plaintiffs obviously may win their case. They're likely to win their case. That's the bad news for us opponents, okay? But there are two more points in those words of the Dyer court that are extremely important. The legislature may also accept the Kansas Constitution's requirements. Therefore, the Dyer case would say that the Kansas Constitution is constitutional. Now, the Dyer case pertains to a case in Illinois, but they would say that the Kansas Constitution may be accepted or rejected by the Kansas legislature. That's what the Dyer case said. And so there can be no supremacy clause argument, there can be no unconstitutionality argument for filing this lawsuit. And therefore, the only reason for this lawsuit can be that Convention of States wants permission from federal court, not Kansas court, to ignore the will of the people of Kansas just to get their way. Finally, let's look at this idea that Dyer talks about, which is the idea of participating in a federal process. Now, they say that the legislature is participating in a federal process when applying for a convention under Article 5. So certainly if a state legislature created under the Kansas Constitution and elected and employed by Kansas citizens can participate in a federal process when meeting under oath to support the Kansas Constitution in a building in Topeka paid for by taxpayers, then certainly Kansas delegates attending a convention under Article 5 will also be participating in a federal process, whether they meet in D.C. or Philadelphia or wherever they meet. So federal courts will thereby say that these delegates are also free to ignore state constitutions and state delegate laws. So the lawsuit against the Kansas Constitution only proves what we have been saying for some time, those of us in our team, in our grassroots team, which is that the delegates, like the legislature, with respect to a convention called under Article 5, may do absolutely what they please. Finally, I would say that I've read Article 5 over several times, many times, and I see only in Article 5 that the Congress shall call the convention. There's nothing about a convention of states. That's a fabrication. There's nothing in Article 5 that says that magically this will not be under Article 5. This convention that is held. There's nothing in Article 5 that says magically we will transport the delegates from under the authority of Article 5 to some little state meeting. There's nothing in that article that says that. Yet that's what's being alleged. That's what's being suggested. And again, Article 5 is, as we know, part of the Constitution of the United States. So I'm referring you to words that you know how to access. Once again, okay, these are very important documents. And the words in these documents are very, very clear. Irrefutably clear. Crystal clear. The people of Kansas deserve better. I urge you to vote against SCR 1604. Thank you for your consideration of my message, and I'll be glad to stand for questions.
Thanks, John. We have 3 written opponents who've provided testimony, and with that, we will reset that and open for questions from the committee for any of our opponents. Oh, Senator Gossage.
Thank you, Mr. Chair. The last gentleman, if you could come up, please.
Mr. Axtell, yes.
Thank you, Mr. Axtell. Thank you for being here. So I'm looking at Article 5. It's rather short. And it just states Congress, whenever 2/3 of both houses shall deem it necessary, as you mentioned, they shall propose amendments to the Constitution or on the application of the legislatures of 2/3 of the several states. So I'm not sure what you're saying when you're saying Article 5 does not allow that.
Oh, it certainly allows for a convention to be called. Yes. It certainly allows for a convention to be called. There's 2 clauses in Article 5. We know both of those. The first clause is what's caused or been the means by which we've ratified the Constitution over a couple dozen times, right? And the second is the means of calling it convention, right? It is true that first steps of calling the convention are exactly as we're doing here. That's appropriate. It is appropriate. What is being alleged is that there is a special process that takes this outside of Article 5 once the convention is called, and that's not correct. Congress shall call the convention, is what the Article 5 says, upon the application of those 34 states. Congress shall call. And it doesn't say, and then those delegates will meet in an authority that's no longer under Article 5. It does not say that. And it gives no hints to that effect. Does that answer your question?
I think so. And one last question, if I may, Mr. Chair, and that is both of the opponent testimonies, I haven't read the written, have been admonishing those of us in the legislature that we somehow are not following the Constitution if we agree with what is being presented with the Convention of States. Could you explain how that's not following the Constitution?
The admonishment that I would make, to be clear, is for those particular people who, mainly in the House, changed the rules, the House rules, to facilitate this lawsuit. And that change in House rules is essentially explained in the Dyer versus Blair case. What the Dyer versus Blair court decided was that because the Illinois legislature had set their own rules, this is a strange, bear with me please, because this is a very strange set of logic that the federal court has applied, okay, in my mind, okay, and I'll just be frank. But in Dyer versus Blair, they came to the strange conclusion that because the Illinois legislature had set explicitly in their own rules, there is a 60% threshold for passage of, or for ratification of a constitutional amendment, and set it as 60% and not referred to the state constitution. Because of that, the Dyer court said, well, you set your own rules, you have to live by them. Does that make sense? Does that? Okay. And so the...
I will
Yep, and so the
others probably have questions. Thank you so much, though, and I appreciate that. Thank you.
It was in the House that the rules were changed, and there are plaintiffs in the lawsuit right here in this room. The people responsible for changing the rules and the plaintiffs are the people we are admonishing to, instead of applying to the federal court for an excuse for changing the standard for ratification or for applying for this, we would want them to honor their oath to the Kansas Constitution as people representing Kansas, not operating in a federal process.
Any other questions, committee? Senator Fasquedo, then Senator Murphy.
Thank you, Mr. Chairman. Thank you, sir. So if this resolution was to pass, so one of the proponents, one of the amendment items would be to address term limits. How would that affect Kansas, us, state senators and state representatives?
Okay, so one of the questions was regarding term limits, and you're asking how the issue of term limits would affect Kansas, and I presume that it would be only regarding congressional elected officials, right, to the U.S. Congress, and not the term limits amendment would only apply to the federal Congress and not this one. Is that okay? Mm-hmm.
Senator Murphy.
Thank you, Chairman. So it seems to me that you are indicating that once something is written, it can't be changed.
We've amended the federal Constitution several times.
And I'm talking rules and all sorts of things.
The rules are new every 2 years here.
Good, thank you. So in our system, what's a remedy if something is not right? Law, Constitution, whatever. What's the remedy?
Well, I fully empathize with the problem at hand, which is that the federal government is out of control. But what do you do when things are not right? Well, you know about the Kansas Legal Tender Act. That's a remedy that's been proposed, and it's been languishing, but thankfully, due to this committee, last year it passed out of committee. That was the right thing to do. That's what to do when things aren't right, is to start pushing back against federal overreach by allowing Kansans to own gold and silver without punitive taxation. That beats back inflation. It helps beat back the debt. It helps people to have a more sound way of saving.
I think we're wandering off the...
And the other thing that we are doing, the other thing that Campaign for Liberty is doing is we've fought against this money, this bribes from the federal government. We've done that regularly, and we've especially fought against socialized health care for years. And we were the premier organization responsible for defeating Obamacare expansion in 2020, when everybody thought it had such strong support that it couldn't be beaten. But it bears mind to mention that Convention of States proponents were almost 40% of those that supported Obamacare expansion in 2020 in the Senate were Convention of States proponents. And so we were fighting against more socialized health care coming to Kansas, and we were fighting against those bribes coming in from the federal government. While Convention of States proponents were fighting for it. Well, the question was, what do we do? What do we do when things are wrong? That's what we're doing.
And you use the courts, correct?
Pardon?
Use the courts, correct?
We defeated Obamacare expansion in 2020 using a grassroots effort.
In what process of the courts, correct?
In the courts? Yes. We did not involve the courts at all. We used a grassroots effort.
The courts were involved through the grassroots effort.
No. In our case, we went door to door and phone calls, and we got senators to literally go from saying, we need a Republican version of this bill on the one hand, to 2 weeks later saying, I oppose this Obamacare expansion, and I oppose it specifically for the reasons that our grassroots effort was using in the messaging to those senators. It was decisive. We did not need the courts for that.
Sure.
This first convention that ran away, you're talking about, what was the result of that?
Well, it was a very good result, and I'm thankful. And Kansas Campaign for Liberty, our motto is to restore the Constitution.
It ran away, and it ended up with a very good result.
I wouldn't believe that would happen today.
And all 14 states ratified it, correct?
13.
14. Vermont was in there by then.
Thank you. Okay.
You're welcome.
Thank you. And in regard to that, Madison did say a couple of things. In Federalist 40, Madison said, as I think has been mentioned, in one particular it is omitted and this is in Federalist 40. Again, this is a very, very easy paper to access. In one particular, it is admitted that the convention have departed from the tenor of their commission. Instead of reporting a plan requiring the confirmation of all the states, they have reported a plan which is to be confirmed and may be carried into effect by 9 states only. They essentially took Article 13 of the Articles of Confederation, which specifically stated the unanimous requirement for ratification of any articles to change or add to the articles. Article 13 was 13 states, unanimous. And they changed that within the convention without sending that out to the states. So they essentially ratified a change to the Articles of Confederation within the Constitutional Convention of 1787. They essentially made that change inside the convention.
Any other questions?
And if that isn't bypassing the authority that they met under and meeting under the authority of we the people.
That's it. Okay. Seeing no other questions, the hearing on Senate Concurrent Resolution 1604 is closed. Committee, tomorrow we'll have a brief from the Secretary of State's office, I believe. Well, no, that's the lottery, I think. Tomorrow is the lottery. Tomorrow's Secretary of State, and then I think we have a brief on lottery on Wednesday, and then we'll hear a couple bills on Thursday. Thank you for your attention and for your hard work today, committee. We are adjourned. Oh, yeah. No, I know.
Thank you. Yes, and I noticed you never supported.
Oh, no, I appreciate that. No, I don't. No. I said the same thing, and also